Good morning, everybody. It being 10 o'clock, I'm going to open the public hearing for, I think it's Senate Bill 563. Does anybody have an agenda? If you would please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So for those of you watching at home, we are going to be going into a recess, but we are going to be holding a public hearing for Senate Bill 563. So everybody knows it is anticipated that the language will be changed quite dramatically. So, just keep that in mind while you are testifying or listening to testimony. And we will be in recess. Just so the public is aware, the hearing, I stand corrected, is for the non-germane amendment to Senate Bill 563, which is 2024-1484, and we are in recess.
Okay, we're gonna open the public hearing on the non-germane amendment. The amendment number in question is 20241448H or 4H. Does everyone have a copy of the amendment? Okay. We have, anyone here to testify on the amendment?
Yeah, there is one that's on the amendment specifically. Did you sign on that?
Yeah, I suppose I should do that.
I don't know, they didn't specifically say the amendment. But that's
He introduced an amendment that is going to be the amendment.
Oh, thanks. He's not allowed to do it when he testifies. Okay. Chairman Roy, you're up.
Hey, thanks. Good morning, everyone. We're here for the introduction of this amendment. This amendment that you have before you, I'm going to propose we change it drastically. And the proposal is going to narrow it down to like a paragraph that's going to define tenancy, an exception to tenancy instead of all this other stuff, which I want to discuss during the work session. So that's going to be the limit of my testimony on this because this, what's before us is going to be altered significantly shortly. So if anyone has any questions, I just ask you to hold them. We're going to discuss this in depth shortly. And to anyone who is going to testify, I would recommend you might hold off too much, but you have a question?
Yeah, I just have a question about the process. So we have an amendment that's before us.
Yeah.
And it may be altered in the work session, and the function, the way that would be, this amendment would be come in as a different amendment. Is that
Same
correct?
amendment, but it'll be,
The same amendment, but it will have a different number or something on it?
no, it'll have the same number. It'll just be rewritten as long as it's germane to
Okay.
this amendment.
Okay, and we'll do all that in the work
Yeah,
session.
we'll do
to
all
see.
that and then
Okay,
we'll
and then
reintroduce it as,
then it eventually gets
yes,
as part of the bill
yeah, if it gets adopted.
when we do that, if it's adopted.
Yep.
And will we be voting on
Vote on
adopting it today, or
No.
does that take place in
Today
the
is
work
just
session?
working. We won't take,
Okay.
we're not going to vote on anything until Wednesday.
Thank you.
Representative Roy, you have to sit back down. We have people who have questions.
Yes.
Representative Sitek.
Representative Roy, I think that's not the process. I think the process is that you don't amend an amendment. We're going to have a new amendment with a new number that may be based off of this modification of this, but this won't go forward.
That will
can't have
be
two
what
amendments.
OLS does when we send over the new
Right.
language.
I'm
Right.
sorry?
If OLS assigns a new number when we send over the language,
Wow, okay.
and we'll have to reintroduce the new one, which is why I'm trying to cut this.
Yeah. It will be a new amendment number, though. They'll assign
Yeah.
us a whole new number. I
Okay.
think that's where there was confusion with Representative
Yeah.
Newman. Yeah.
Bottom
Okay.
line is this is not going to be what we're working.
Right, right. But there will be a new amendment number because it'll be just a different amendment. Okay. I'm not sure if this is Nick Norman or Horman. You can't, yeah.
Nick Norman, thank you very much for the opportunity to speak with you.
Hello,
Based
Mr.
on
Norman.
what Chairman Roy said, I'll keep my comments quite brief because I understand that the whole amendment's going to be largely rewritten. I work as an advocate for housing providers. I wrote to everyone last night. You got an email from me. I'm normally before Judiciary and Commerce, so you don't see me too much because you don't often take up landlord-tenant bills. But I've been working for about 13 or more years advocating for property owners around the state. I'm very active in that with anything involving new landlord-tenant law. We have about 3,500 members that we're in touch with, and we send out legislative updates during the legislative season every week. So I let you know that to say that I'm very involved in landlord-tenant law. I'm often in the process of working out compromises and languages and helping people to come to some win-win situations. And I have a core team of experienced investors and attorneys, and we'd be very happy to help you with this language. And I would like to offer that. The concept, I think, is important and needed to be able to quickly remove illegal, unauthorized, people that are illegally taking possession of a property. The idea that it would have to be written leases is extremely troublesome because many, many people have valid reasons to be at a property that's not under a written lease. So I can see that there's quite a large number of issues with the way it's currently drafted. But I do believe it's something that would be needed to be able to quickly remove illegal squatters. So that's basically it. I would love to be a resource to you. I'll give you my phone number is 603-432-5549. I'll give you my hard to remember email, nicknorman@yahoo.com. And I would invite
Thank
any
you.
questions.
Thank you, Mr.
And I
Norman.
plan to be here during your work session if you want to
Thank you
speak
very
any
much.
further.
Are there any questions? Seeing none, thank you very much.
Thank you.
Jessica Margson?
Good morning.
Good morning.
I will try and keep this brief also. My name is Jessica Margison. I am a tenant organizer with GSOP, but I am here speaking on behalf of myself today. The reason I oppose this bill and think it's a horrible overreach is it passes and removes many due processes in the process of enacting. So when the owner of a property or law enforcement acting at the request of the owner may, without need for legal process, immediately remove such person. A lot of times I'm helping tenants who were illegally removed with a 548 to get back in their apartment. This removes all due process for a person to be able to stand up and say this isn't right. The next part of without due process is with no advance notice being required, guilty of a misdemeanor criminal trespass, and any property left occupied dwelling shall be deemed as abandoned. This is already hard enough for many tenants trying to leave their property to get stuff out within 7 days. I can relate this to a personal story though. Where I was living at for the past 2 months, I did not have a lease. I did not have anything written in a contract. I was quite desperate to get out of my car and into a home. So fast forward to about a week and a half ago, my person I was renting a room from decided they wanted to do something different with that room. They started picking up my stuff and trying to box it. Luckily, the police were called. I had to keep tape recording out of safety. And the cops reminded them that there is a process for this and that I legally live there and they can't go about doing this. So they thought they were in the right by doing this. If we have a landlord that thinks they're in the right, you have an opportunity here where someone could be illegally removed from their place and lose everything they have. I at least have a little safety there of the 7 days to go back. And luckily our police department did know the rules to be able to let them know. And in my experience, not every police officer knows these laws. This seems to be something created to fix another problem and done horribly wrong. So I vehemently oppose this bill and hope everyone does too. Thank you.
Thank you very much. Mr. Kremer?
Good morning.
Good morning.
My name is Ben Kramer. I represent New Hampshire Youth Movements. I live in Newmarket. My organization is a young people's organization across the state. We have over 100 dedicated members, more than 5,000 supporters. all ages 15 to 30 in the state. And I'm here to testify on behalf of young Granite Staters and as a young Granite Stater myself. I oppose this amendment. We also oppose the underlying bill. I'll keep it brief, knowing that there are changes coming to this amendment, and would caution you to apply what I'm about to say to any proposed changes. I think the biggest concern with this amendment is around due process and unintended consequences, both for this amendment, and that's a concern that I would apply to any future changes. As others have said and will say in this testimony, many people in this state, particularly young people living in their first apartment, college students in their first time away from home, don't have access to written leases. Many people don't have a written lease, and that's fine. And this amendment would place them in an extremely precarious position. I myself, when I was in my first apartment living on my own in college, I did not have access to a written lease easily, didn't really know how that works. It's very concerning to me to see legislation that would make those people in a very precarious situation to be removed without due process. To set the stakes here, I think it's important to underline that any law that makes tenancy more precarious in this current housing crisis that we're in, it will increase homelessness. And New Hampshire is already the fastest rising rate of homelessness in the country. Last year, homelessness rose 52% in the state. And that is the fastest rising rate of homelessness in the country. So I think it's important to appreciate the stakes here. And for this amendment, that makes tenancy extremely precarious. And any future amendments related to tenancy, I would ask you to bear that in mind. We need to protect due process for eviction. We need to require good cause for eviction and give tenants their rights to due process before they're removed from housing. And I would urge the committee to oppose this amendment. I would also imagine that, I'll read the amendment when it is posted, but for the future amendment, I would bet that if it makes tenancy more precarious, I would oppose that too. So thank you.
Thank you. Representative Murphy, do you have a
Thank
question?
you. I actually just have a question in the chair.
Yeah.
Since what we're, pardon? Yeah. But my question is, what we're talking about and what people are testifying on is the amendment as written. And we've been told that there's going to be changes. So will the people that have come to testify have the opportunity to testify to whatever the final amendment as proposed is? Because they're limiting testimony based on the fact that we assume there will be changes made. So I want to understand whether or not they'll have the opportunity for input once we really actually have the amendment as proposed.
Yes,
Perfect. Thank you.
you're welcome. Mr. Barry? Mr. Barry, allow me to tell you thank you for coming back to join us again today.
My pleasure. Thank you for having me. For the record, my name is Elliot Berry. I'm here as a private citizen, having retired from New Hampshire legal assistance in 2023 after 47 years. I think in 47 years, it's fair to say that I've represented more tenants than anybody in the history of, for better or for worse, than anybody in the history of the state of New Hampshire. I want to start out again by being clear that my testimony, which is strongly against the amendment as written, is not meant to impugn anybody's motives. But there are plenty of unintended consequences. And before I point them out, though, I'd like to say something to make something very clear. This has all arisen, I believe, in the context of a sudden national scandal about squatters, based on cases that allegedly happened in New York and happened in California, where apparently after 30 to 60 days of being somewhere, you have some kind of rights as a tenant. Please understand, in New Hampshire, with one exception, the law does not recognize any squatter's rights. What is that one exception? If you openly and notoriously occupy real estate for 20 years, then you have rights to adverse possession. That is the totality of squatters' rights in the state of New Hampshire. So the question, though, becomes then, who is a squatter? And that's a complicated question. And one of the things that I urge this committee to do, I believe we could work it out. As Nick Norman suggested, even, the landlords too recognize that throwing people out of their homes precipitously without a lease and without process is bad policy. But understand that I can't see any basis for such a somewhat complicated issue to be decided upon on such short notice. I mean, whatever the problems we have with the current law have existed for at least the last 38 years. So what's the emergency that is driving this? So I would really urge you to hang on to either send it to study or to have somebody bring it back next session. But let me just highlight a few of the problems that you, if as you go through your work session, you can think about. First and foremost, by requiring a written agreement as a requirement of a tenancy, the bill totally eliminates the law of implied contracts in the context of landlord-tenant law. There are two kinds of implied contracts. One is an implied in fact contract, which is based on inferences drawn from the behavior of the parties. So for example, a girlfriend moves in at the request of her boyfriend, who's a lawful tenant. The landlord says, okay, if you pay me an additional $50. There's nothing in writing about moving the girlfriend in. The tenant agrees, they pay, and after 6 months or so, there's domestic violence, and the quote lawful tenant moves out, and the girlfriend is in the apartment. She's been there knowingly for 6 months, but she doesn't have a written rental agreement. Under the amendment or any such requirement, she's going to be subjected to being forcibly removed, arrested, charged with criminal trespass, and perhaps convicted without any notice whatsoever. I hate to, but that's just, again, I know it's not intended, but that's the kind of situation that's going to be opened up. And this is also true. A lot of, especially elderly tenants, don't have a lease, and especially those who are renting from non-professional landlords. And the same problem is posed for them. Or a college student who comes back after he graduates with no job, and unfortunately that's happening more and more in this society. Parents move to Florida. He was there knowingly for months and months, if not years. Landlord gets unhappy. Bingo, he's gone because he didn't have a written agreement. That is not going to work. And especially when you pile this on with arrest for trespass and possible conviction without any notice whatsoever. Regardless of the intent, the amendment would strip untold number of New Hampshire citizens of their legitimate rights as tenants without any opportunity to explain their claim of tenancy to a judge. It would precipitously throw them into the most difficult housing market the state has ever seen and make them criminals for perfectly legitimate behavior. Nothing in the current law protects a person who moves into a home or remains there without permission of the owner or a lawful tenant. It's trespass pure and simple under RSA 635, Section 2. Notwithstanding the chatter in the media, there's nothing happening in New Hampshire that warrants dealing with this issue outside of the normal legislative process, and that's what I urge you to do. I'd be happy to answer any questions.
So, Mr. Berry, I just, if you could, you had talked about if a tenant says, "Hey, can my significant other come live with me?" and the landlord says, "Sure, $50 a month," and it's a verbal agreement. If we could turn the table for a minute, and what happens? What is the process when the tenant stops paying the $50 and the tenant says, "Well, there's nothing in writing that says that I had to pay this $50"?
Yes, well, then you have a hearing in court to determine whether the parties ever agreed to that. My guess is in most cases, they're going to be canceled checks, or maybe I'm an old timer, maybe nobody does that anymore, but rent receipts. And the judge will decide whether whether or not there was an agreement. And that's what, that's one of the things that's sorely missing here is the opportunity for an alleged unauthorized tenant to establish that he or she is an authorized tenant.
And could you just give us the time frames for those? 30 days for this, 20 days for this.
Sure. The vast majority of evictions are non-payment, and they're going to be, so in your example, you'd get a 7-day eviction notice followed up by a court process. It's probably going to take about 30 days from beginning to end. For other cases, if it were for unauthorized tenant, which you can certainly bring an eviction for in this state, the eviction notice would provide 30 days prior notice and then an additional court process.
So the 7 days,
For
and
non,
then
for non-payment, for damage or behavior which materially adversely affects the health and safety of another tenant, 30 days in all other cases.
okay. So if you could, so my understanding is you have to notify the person of the eviction, and so once they receive the notification for the eviction, is it 30 days that they have to?
Yeah, 30 days. Some will move out within those 30 days. Some
Okay.
will wait until they are served. After the 30 days, they'll be served with a summons to go to court called the landlord-tenant writ, and then they'll fight it out in court as to whether they're that non-payment or the 30-day, whether they are in fact an unauthorized tenant.
Okay, so 30 days, and then they can go to court,
Yes.
and then they have to wait for their court date.
Yeah, which are pretty. Normally, that court date is going to be about between, I think, 10 and 20 days after the hearing. I'm sorry, after service of process. Normally, but some are longer.
Okay, so the reality is the 7 days, the 30 days, the 20 days is, would you say reasonably 45, 50 days?
If it's for a 30-day eviction as opposed to non-payment 7-day, then yeah, I think that's probably right.
Okay, thank you.
Can I just add one thing,
Certainly.
if I might? Your questions underscore that there's a lot more going on here that you're being asked to deal with than just what's covered in the amendment. And I think that just underscores the need to have this done in the normal deliberative process.
Thank you. Representative Newman?
Thank you. A question I have is I noticed in the amendment that it authorizes police officers to use reasonable force during the eviction process itself. I know that currently this is a civil matter where sheriffs are used.
That's absolutely
Do you
true.
have, I mean, do you have any concerns about authorizing police officers to use any level of force in these matters?
I do. I haven't, and my only parenthetical to that is I've never practiced any criminal law, and I'm not. It's not my area of expertise, but sure, I absolutely do.
Follow up?
Could you elaborate on that a little
Yeah,
bit?
I mean, again, if the people who are very experienced in serving what they call writs of possession, the document that the landlord it takes to actually remove the tenant, as you said, those are sheriffs, and I think that they're the ones who are experienced enough to know how to get it done in the maximally safe way. I think, the police, you bring the police into the process, and I think their orientation is a lot different and their experience is a lot different. And I just think it heightens the tensions around a very tense event in the life of ordinary tenants and sheriffs.
Representative Newman, I apologize. I meant to say Representative Muse when I said your name earlier. Representative Reed?
Thank you, Madam Chair. So how would you ideally remove people who don't want to leave if you don't use sheriffs or law
Oh, no, I'm not. This happens. Look, I was checking this the other day. There were actually about 3,500 writs of possession issued in the past year, where the sheriff goes and peaceably removes the tenant. It's a situation that happens almost every day. And I think unfortunately, that's something that has to happen. So I'm not opposed to that. This issue of how much force ought to be used and who's the best to figure out a way to remove those tenants, I think that's a more complicated question.
Mr. Barry, I just have one more question. What are the months? My understanding is, I'm not sure if it's just the winter months, if it's like October through April, November through April, that a person is not allowed to be evicted in New Hampshire for the winter.
If I can just tell you a very brief anecdote. After about 5 years of practice, where people, especially mothers with children, would come into my office and they'd say, I got this eviction notice, but I can't be evicted because it's wintertime. And finally, I heard it so often that I worked with a sponsor to get a sponsor for a bill to say you can't evict somebody in the wintertime. It is not now and never has been the law. Evictions go through every month of the year.
Okay, thank you. Representative Newman?
Thank you, Madam Chair, and thank you for taking my question. Could you just briefly talk about the part of 540 that's being amended now that talks about evictions in 7 days and 30 days notice? Just kind of to help us understand when there's a dispute and the money's not paid.
Sure.
And then something happens, and at what point in that process would it come to the point where a writ of possession would be used to get them out of the property?
Sure. So all lawful evictions start with the issuance by the landlord of something called an eviction notice, used to be called a notice to quit. It's going to be either 7 days, it says you have to vacate the premises by either 7 days from service or 30 days. It's 7 days if it's non-payment of rent, damage, or behavior which materially affects the health and safety of another tenant or the landlord. Those are 7 days. Everything else is 30 days. If the tenant remains in the premises after the date on the eviction notice says they have to vacate by, then the landlord serves what they call a landlord-tenant writ, which is a summons to go to court. The tenant usually has 7 days from the date of service to file an appearance, which is the equivalent of asking for a hearing. The hearing will usually be set 10 to 15 days. Sometimes it's less, minimum of 7, sometimes up to 15 days later. And then after the hearing, if the landlord prevails, the landlord, what they call a writ of possession will issue on the 8th day following the hearing. And then the sheriff serves that writ of possession, and the tenant is hopefully not on the street, but all too many times in these days they are.
Follow up.
And if the bill was written substantially to have that, or as written right now, takes all of that due process away, is that correct?
For tenants who don't have written leases or rental agreements, of which there are many.
Thank you.
Thank you very much, Mr. Barry.
Thank you.
Grace Kandecki? Welcome back.
Thank you so much. And thank you to all the committee for taking my testimony today. My name is Grace Kandecki. I'm the program coordinator with the American Friends Service Committee and a longtime New Hampshire resident living in Manchester. So I'll keep my comments brief. I think there have been far more expert witnesses who have come before to testify. But I'll simply say that I understand that the amendment will be changed. And so I'm really speaking to more the spirit and the intent of this bill, and to really urge the committee to take into into consideration the vulnerability of the populations who will be affected by an amendment such as this. And I absolutely underscore the comments that the gentleman before me spoke of the importance of recognizing that this is a very complex issue and giving it the care. And I know that this committee, as it so often does, will give it that care and attention that is needed to underscore the complexity. And so I just wanted to talk about just very briefly the importance of balancing intent over impact and recognizing what is the problem that is trying to be solved by this bill. I have the privilege of being a homeowner, but I was a long-time tenant and renter for the majority of my life, living up here in New Hampshire, as well as when I was living in Boston. I've unfortunately had the experience, both as a child and as an adult, to undergo eviction processes, to witness eviction processes, which are very difficult and painful experiences for anyone who's has ever gone through that themselves or has witnessed it. And so again, thinking about the impact that this bill will have on already vulnerable people, as we're talking about people who are, in situations where they are living without a formal lease, whether that be family members, whether that be partners, whether that be, and especially particularly thinking about within my own community, BIPOC community, immigrant BIPOC community here in New Hampshire, where because of our housing, our lack of affordable housing, we do have people living, more people living in a home than there are bedrooms, simply because that's what people have to do in order to ensure that, they can survive, that they have a place that they can put their head down that is safe and free from the elements. And so I just really urge the committee to really take into consideration, again, like, what is the intent, the intent of this bill, what is the impact that will have on our New Hampshire residents? That this committee is tasked with safety, community safety within our state. And does it make us more safe? Is it just to put forward an amendment that would needlessly harm and burden tenants who are in situations that are already vulnerable? Is it the committee's goal to make life harder for already vulnerable populations? Or is it the committee's goal to ensure that those vulnerable populations are protected while also balancing the interests of our landlord community as well as our other interests in that? And so I just wanted to just really come up here and really urge the committee to really take into consideration, especially considering what bill this particular amendment is attached to, and that there are better ways for us to approach the needs of balancing different interests, ensuring that we are securing housing, that we are creating safe communities, but targeting already vulnerable populations who will undergo already difficult processes, and creating a process in such a way that their own rights are not protected, that we are deputizing landlords to remove tenants, that we are sort of putting a vulnerable class of people sort of outside the law, I think is very alarming. And so I look forward to seeing the new language for this bill. I look forward to Representative Rhodes introducing that. And I look forward to being able to testify on that as well. But again, in the crafting of this, I really strongly urge you to take into consideration that public safety means public safety for all. Thank you. And I'm happy to take questions if there are any.
I don't see any. Thank you very much.
Thank you.
Representative Horgan.
Thank you. I'm Representative Timothy Horgan, and I actually came in today for the bills down the hall in education, but hopefully I can add something to the debate. I usually sit on the House Judiciary Committee, which usually gets bills about evictions, and we get them every year. So there's always we always get bills that make eviction easier, and that's not necessarily a good thing. This goes way farther than anything else that's ever been submitted. So like if the sponsor thinks it's a good idea, they'd probably be better off waiting till the next filing period. And if they're reelected, they can bring it back in 2025. Believe me, we've seen lots of bills about this before. I know, I do know like at least one or two of my constituents. I'm Timothy Horgan from Durham. But 20 people that are worried about it. And they say there's scores of stories which show why this bill is needed. I have not heard any of those scores of stories. If you wait till next year to submit it, we'll have like the usual process would take several months, and perhaps we can hear and evaluate those scores of stories. So right now, I see nothing that says this bill is needed. It goes like very far, especially you get law enforcement involved, before there's any proof like whose property it is or whether, whether they actually even deserve to be evicted, especially the part about taking people's property and letting the owner dispose of it as they see fit. That's like a very extreme measure. And I might also add, since this is in criminal justice, and I know there's several Second Amendment stalwarts in here, there's no carve out in here for firearms that are abandoned. So that's probably reason enough right there to either, that's something, maybe you might try to amend that bill to put in a carve out for firearms, but I think that's probably reason enough right there for many people on this committee to vote no on this amendment. People's guns can be taken away and all their other property, but I know, at least in some people's minds, guns are special. There's even more valuable than other property. So I would just say, this amendment is premature. If you think it's a good idea, I say wait till next year, and the Judiciary Committee can deal with them as we deal with these bills every year. And I'm also not particularly enthusiastic about the underlying bill either, but that's a matter for another day. And most of these squatters we're supposed to be worried about are not going to be necessarily undocumented immigrants anyway. Most tenants are citizens or green card holders. But so that's basically why I think this amendment is a terrible idea. So I urge you to kill it. So I'd be happy to take any questions if you'd want. But
Seeing none, thank you.
yeah, so if I'm back in Judiciary next year, if I get reelected, I'm sure I'll see more eviction bills. So thanks.
Thank you, Representative. I would like the public to know that the sponsor of the amendment is not the one that makes the decision of where the bills are heard, whether it's criminal justice or judiciary. Is there anybody that wishes to testify on the amendment that has not turned in a pink card? Seeing none, I will close the public hearing for the amendment 2024-1484H. The committee will take a 15-minute recess. We will be back at 11:15.
Okay, we're going to start our work session on the underlying bill. With regards to the amendment we were just talking about, that amendment is going to actually go away and a new amendment will be drafted for a non-germane for another bill, and we'll have another public hearing on it next week. So we're talking about the underlying bill here. The amendment, the non-germane amendment that we just heard, is going to, we're going to get rid of that, and there'll be a new non-germane amendment attached to a new bill that we'll hear next week. So it'll be like a do-over. So the bill that we just heard, we're going to throw it out. That's correct. The amendment, not the bill. Yeah, 563 is still going forward though. So we're going to be talking about 563 now. The bill itself. It's a work session for the bill.
Question,
Well, it said both.
que-
I thought it did.
question for the chair.
Yes, sir.
Could you, so what you just said, and you said it pretty fast, we,
So we're gonna-
we will have a non-germane amendment and it will not be associated with this bill. It
That
will
is
be
correct.
associated with another bill.
That is correct.
Thank
And
you very much.
And we'll take that up next week.
That's fine. Thank you. And it will be properly noticed. I
Yes,
appreciate
that
it.
is correct.
But it'd be a non-germane for 563.
No, 563 is now, we're going to just deal with 563.
As,
The bill.
as introduced.
Yeah, I'm cutting that loose. Everybody understand?
Yeah.
Okay. I would think so. All right, just as a generality on the underlying bill, I think we're all in agreement that it is very, 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 very broad. There are pieces of that bill, I understand what they were going for, but this thing about using, does anyone have a copy of 563?
Yeah.
Could I see your copy?
Oh, here you go.
I got it, thanks. With particularly the part that I found very troublesome, that said law enforcement agency shall use its best efforts to support the enforcement of federal immigration law. I found that extremely disturbing. It's broad. It does, what does that even mean? We have repeatedly said that we want to limit federal involvement in our law enforcement's interactions as far as enforcing federal law. So I feel like this bill is very overbroad in that respect. So does everyone pretty much agree with that? That section is problematic? Anyone else want to talk about that? No? You guys are okay with it? Either or. So you agree that it's okay. So I think that in the effort of we're going to look, the rest of it just seems to be more to do with definitions than anything. What I'm proposing that the only thing that we should be doing is prohibiting law enforcement from being allowed to cooperate with regard to detainers. In other words, I don't want law enforcement asking anyone their citizenship status or any of that stuff. If someone's arrested for a New Hampshire crime and they're booked during the process of the booking for a violation of New Hampshire law, it becomes evident that there's an ICE detainer. I think our law enforcement should honor that detainer. But as far as inquiries about someone's citizenship before they're there for another reason, that goes way too far as I'm concerned. And that goes for this thing about shall use best efforts. I feel like that's overly broad. Further discussion? Representative Sytek.
It sounds like you're proposing a one-sentence amendment.
Pretty close to it, I would think, yeah. Further discussion. Representative Mannion.
Thank you. Just throwing this out there. So if you have occasion to run across somebody for a traffic violation, you don't arrest them. However, you run their name and a detainer pops up. Are we prohibiting law enforcement from acting on that detainer even though the person isn't under arrest for any New Hampshire offenses?
It depends. There's several kind of detainers, in my understanding. There's criminal detainers and civil detainers. Is that correct?
I'm not sure.
Yeah, I
They're
think we
different.
would need to find that out. If it's a warrant, then I would say no. They have to a warrant. But if you have them in custody in any way, could you please notify us? Type of thing. That's different. I don't think that we would be arresting on detainers because they're not a criminal. It's not necessarily a criminal warrant. So if there's a criminal warrant, then yes. If there's a ICE detainer, I think they can notify ICE that they've been in contact with that person, but they can't take them into custody based on a detainer. But I am going to ask that to make sure, but I believe that is the state of the law. Further discussion? Representative Muse.
Yeah, I'm not sure that that fixing that one particular area actually fixes this legislation. One of the other things that this particular bill does is it essentially functions as an unfunded mandate on local law enforcement officers, and unless we remove things like all of section, basically the things that are listed in section 6 of the bill. So forcing local law enforcement to comply with an immigration retainer, complying with a request from a federal immigration agency to notify the agency, providing federal immigration agency access to inmates for interviews, participating in any program or agreement authorized under Section 287 of the Immigration and Nationality Act, whatever that is. There's just a lot of stuff here in this particular bill, and a lot of things that our police officers, I don't believe, are trained for at this standpoint. And I think similar to the issue that was raised on the on the squatter bill, once again we have New Hampshire police officers and law enforcement officers sort of thrust into situations that they don't have experience with and that they're not trained for, and that creates situations where we could have a lot of unintended consequences. I think the other thing that's worth noting in the context of this particular bill is, we are not Texas, we're not Arizona, we are not a border state. And the need for this, I think one of the things we always have to ask ourselves as legislators is whether or not there's actually a need for a particular bill. What's the problem that we're trying to solve? And I think the problem that we're trying to solve with this particular bill is that Fox News has nonstop 24/7 coverage of the southern border crisis, and that we would kind of like to have our own little piece of it here in New Hampshire. And unfortunately, I just think that it creates a lot of additional problems that we're not prepared to solve at this point.
Well, I would say that I watched this morning, and they weren't covering the border crisis. They were covering the unconstitutional persecution of President Trump for a little while. But that being said, we have a southern border with a state that advertised itself as a sanctuary state, and they have actually screamed out for help because they've overwhelmed themselves with their number of undocumented immigrants. So we are beginning to see an influx into our state. We are a border state. We actually border Canada. So I don't know what the southern versus northern border has to do with it, but it's a border. But I feel like if we limit this down to things that are already being done, I'm quite sure we do have training in complying with an immigration detainer. That's not an unfunded mandate. Complying with the request to notify them, that's a phone call. That's not an unfunded mandate. Providing federal immigration access to interview an inmate, also no cost there. And participating in any program or agreement authorized by federal law. I'm not sure what that means in all honesty, so I am going to look it up. I wouldn't advocate for that until I know what it means. And providing federal immigration agency with inmates' incarceration status or release date, also no cost to let them know when the person is expected to be released. Representative Mannion.
Thank you, Mr. Chair. Yeah, on that note, as far as unfunded mandates, we hold people on warrants out of Massachusetts, New York, California, all the time. There's no extra funding to hold that person. ICE detainer is no different. You're holding somebody for another agency, whether it's 24 hours or 48 hours. I've heard a lot today about the lack of training our local police have, and that only sheriffs know how to evict people from property, and only the federal government knows how to deal with ICE detainers. That's incorrect. We go to the same police academy as the sheriffs. We have the same training, sometimes more training. There's training on ICE detainers, there's training on federal law, there's training on local law and state law, and evictions as well. Criminal trespass is criminal trespass, whether it's a sheriff enforcing it or a local police enforcing it. So as far as training goes, the training is there, just to dispel anyone's suspicion of otherwise, but it is also not an unfunded mandate. The money's there. It's already being done.
In your experience, have you held ICE detainers? Have you had any interaction in your experience with ICE as far as them coming to talk to people or anything like that?
I have not personally, but my agency has. And like I said, it's within 24 to 48 hours. And outside of that, they'll be released if they don't pick them up. But it's no different than if Massachusetts has a warrant for somebody and we hold them for them and they come pick them up. It's the same scenario.
The role we would play is just notifying them that we have someone in custody for another crime. So again, I don't see how this would cost any more. All it's doing is complying with federal law and assisting our federal partners without inconveniencing New Hampshire citizens, because we're not going to be asking them any of these things unless they've been arrested for another crime. Further discussion. Representative. Oh, Linda.
Nope, go ahead. I have had several ICE detainers, and it's a simple phone call. They'll either say let them go or hold them. One of my cases was a Honduran national, big-time drug cartel dealer. You could not even tell. He was super nice. I ran them. They said, we'll be down in about 5 minutes. They came from the Concord office. They'll also come down from Vermont. That's all it is a phone call. And they say yay or nay, and that's it. There's no sort of unfunded mandate whatsoever.
Is there any time limit as far as how long it can take to come get them?
That would be a court issue. It's that reasonableness, how long to detain someone roadside. It's kind of the call of myself or the ICE agent. They were always there very quickly, so I can't speak on the actual time limit for that.
So that's a roadside stop where they came up as a detainer and you called from the side of the road? And they
Yes,
asked you-
it was for like a speeding violation. I ran the guy, he gave me his information, and it popped up on the screen, immigration enforcement hit, call this number. I would call and either a yay or an nay, and that was it.
Okay. Representative Harriet Gathright.
Thank you, Mr. Chair, for taking my question, but I'm concerned about this bill, and particularly the original bill, because we had so much testimony, even from our police department. And I struggle with that because we've counted on them in so many aspects of the law and how we treat people and those types of things. And when they say to us that right now, today, if someone is have committed a crime, you know, they get the regular treatment like anyone else. It doesn't matter. So if that's the case, why are we still doing this with this bill? So again, this bill just seems like it's trying to solve a problem that really doesn't exist here for us. We've had many, the border control, we've had the come before us over the last couple months for different reasons. And no one has ever said there was a problem, not one. Not even the law enforcement that was in that area near the borders with all the bills that we've heard this year. So I guess for me, I'm really struggling with this bill. The fact that it's even here.
Didn't we hear, correct me if I'm wrong, I believe we heard there was a mass murderer that was hiding right in our, is that, did we?
Yeah.
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 In Rye. So that's New Hampshire. So I think that's a problem.
Yeah, but there's Timothy DeVays and all those people hiding too.
Who's?
It depends on what you look like. Come on.
I don't think mass
bills.
murderer is
Yeah.
anything to do with
No.
race at all.
That was one case of a mass murderer.
How
from
many
another
mass
country that
murderers
was
do we
here.
need? Representative Singh.
Thank you. Just a point of clarification. So it feels to me like we're having an executive session talking about the merits of the bill. And I'm just trying to clarify what our purpose is in a work session in terms of what are we hoping to get out of this time today, just because I couldn't fully hear what you were saying at the beginning. I don't know whether it was the audit, the room, or myself, but I'm just trying to figure out, is our goal that we're trying to see if we can find an amendment to this bill we can all agree on, or are we just debating the merits of the bill?
I think both of those two things. A work session is so that the committee can come together and look at it and say, is there anything in this bill that we could make better, that would make it serve a purpose that would be justifiable
Okay.
and in further the public safety?
May I
You
comment?
may.
Thank you so much. So I have to say, I have objection to the underlying premise of the bill that we have all of these challenges. And part of the reason for that is, I have relatives who attempted to come over here in the 1920s and 30s, and their boats were turned away because they were threats to this country. And so they are no longer my relatives because they all ended up back on the other side of the ocean and then in gas camps. If we continue to have policies that are anti-immigrant, anti-human, and anti-humane, I think it ultimately creates major problems. The majority, I'm not saying every immigrant, but the majority of people who are immigrants to this country, whether they come documented or start out documented and become undocumented, or whether they ultimately come here without documentation, the majority of them are coming because they are desperately trying to find a way to better their lives. And I feel like bills like this puts them in a category of making them less than human, and puts them in a category where it's easy for people to discriminate against people purely because they're trying to get out of a desperate situation.
So it's your position that if someone has a detainer on them from ICE because they've broken a law, be it not showed up for their hearing or any number of laws that ICE has put a detainer on, and that includes also convictions for other crimes in other jurisdictions, that makes them less than human?
No, my premise is the way that this bill is written. It refers to people using language I personally find offensive.
Oh, yeah, but we're talking about
And
changing it, so.
I understand that, but I find that the underlying premise of the bill is one that dehumanizes people.
So the premise of the bill is that there, in my understanding, because I didn't write it, is that there are several communities in the state that have declared themselves so-called sanctuary states, cities, and they've prohibited their police departments from cooperating with ICE. So the premise of the bill is that as a state, we don't want our cities and towns deciding which federal laws they're going to let their police officers
But
ignore.
we've also decided as a state, we're not going to enforce a number of other federal laws.
We're not enforcing federal law though here. That's what I want to change. I want to make sure we're not enforcing it. We're just recognizing it.
But we've determined that we're not going to recognize other federal laws. So
Which ones?
there are a number of gun laws that we've decided we're not going to.
Which ones?
We are not dealing with guns in schools appropriately. People
Yeah, we
can
are. The law says
walk
you-
with a gun in a school, but we can't do anything to enforce it based on laws that we passed until they actually start to fire.
No,
their
no, no.
weapon. That's
Federal
one of-
law on guns in schools is unless you have a license to carry, you can't bring a gun in a school. So we enforce that law.
I disagree.
I mean, I don't want to conflate lawful immigration or actually even unlawful immigration. This is, we're talking about dealing with people who this ICE under this president has said should be held. We're asking you to hold these for us. And we have cities and towns that are saying no. So, I mean, that doesn't seem to be a safe way to run a state or a country. If we can't get people that the federal authorities are saying, hey, we find this person needs to be held, be they on a terrorist watch list, a mass murderer, or they just didn't show up for their court hearing.
If someone has a thing out for being a mass murderer or for being, I forget what the other term you just used was, aside from their immigration status, presumably there is a different type of retainer as well about them having violated some major crime.
Well, that's what I was
Other than
asking
just
him about.
immigration.
Yeah, is there a difference between a detainer for example, missing your court date versus a detainer for you've committed a crime and therefore.
Absolutely, but just as there should be, you know, if someone were to be in Massachusetts beating a partner and be guilty of domestic assault and having fled to New Hampshire, that person should be held just in the same way.
Yeah, sure. Go ahead.
So in that case in Rye, the crimes were committed in Brazil, I believe. So we have no authority or no jurisdiction there. So there would be no warrant or anything else for us to arrest him on that crime in Brazil. This was strictly a detainer because of the person he was, that he was held on and ICE wanted him. Different than Massachusetts.
And we honored that and sent him back. We didn't hold him because of that. And we have a lot of people committing crimes and murders in this state and in other states in this country who are lawful U.S. citizens, and it happens all the time.
But what if that person was in a city or a town that prohibited their police from detaining that person?
Then there's still ways that ICE handles it.
If they don't know the person exists. Representative Reed.
Thank you, Mr. Chairman. I think I like to look at it this way. You know, we're public safety, right? And we're protecting the immigrant community as well, because people come here, the legitimate people come here for a peaceful, productive life. We're allowing people in that have nefarious histories or motive. They're hiding in these communities. I feel if somebody's stopped and they have a retainer, we're not only protecting the public as a whole, but we're also protecting the immigrant communities from people who will be in those communities and possibly posing a threat. But because we're not calling ICE to decide if they should come for them or not, we're putting a community at risk who would not ordinarily reach out to law enforcement, and those people are hiding in the community, potentially harming those communities who will not speak out. And I use the example of migrant workers in North Carolina that come in to harvest the tobacco, cotton, whatever. They're a quiet community that sticks to themselves, yet we have people coming in from Venezuela, MS-13, and they're infiltrating those communities. Those communities aren't going to say anything. I feel that it's the police, that it's a safety thing, that if somebody's picked up, they have a detainer, that ICE should be notified and it should be dealt with. It protects everybody involved, legal or not, or otherwise.
And I think I want to reiterate, it's important to know we're not proposing, or whatever the bill says, it wouldn't, coming out of this committee, propose that our law enforcement ask anybody about their immigration status at any point prior to their being arrested and being flagged in the system as being wanted. So we had some letters from police chiefs, and I gave those their due attention, and it talked about interfering in the relationships they had built in their communities, and I think that's invaluable. I wouldn't want our police to start going into communities, start asking people their immigration status. That's why we have a federal agency that handles that. But this is specifically talking about once someone has violated a New Hampshire law, taken into custody for that, or stopped for a violation of New Hampshire law, and an ICE detainer is flagged in their system. At that point, what we're saying to the officer, if we are in one of these sanctuary towns, is ignore that. And I can't in good conscience say to the citizens in New Hampshire, this person's wanted federally. We're not sure for what exactly. It could be anything from murder to whatever. And we're just going to ignore that and let them go. That seems incredibly reckless. And it shows a disregard for the federal court system, the federal law enforcement system. And I just don't see how we can justify that. As long as we keep it where in the lane it belongs, which is someone who has already been processed by this ICE agency, and they have a lawful detainer on that person. It's not just us randomly picking people up. Representative Murphy.
Oh, thank you. Not relative to the merits of the bill, actually, but just to the financial impacts. I am aware, and I don't have all the specifics. I wish I did, but I know in Merrimack, there's actually a lawsuit against the Merrimack Police Department for their efforts regarding they did detain somebody for ICE, and ICE didn't show up. So I wish I'd have to get all the specifics, but I do know
Can you
that
get
they
them?
are involved in a lawsuit. So it is costing, a municipality,
I'd like
trying
to,
to do that. Yeah, and I
Can
can
you
I
get me
find
that
out.
information?
Sure.
Thank you very much, because that would be important to know. Representative Muse.
One of the things I just want to make sure we're all on the same page about is we're not necessarily talking about rapists, murderers, and kidnappers. We're also talking about people who might run a stop sign. We're talking about people who might be arrested or cited on a violation level offense. And one of the things that I want to call everybody's attention to is the letter that Chief Aldenberg, my police chief, and several other police chiefs sent to us that basically said, and I'll read you one paragraph. To be clear, police officers already possess the ability and authority to enforce violations of local, state, and federal criminal statutes. Indeed, all police departments in New Hampshire coordinate with federal agencies to apprehend individuals, no matter what their citizenship status, who may have engaged in crimes. But in our humble opinion, as law enforcement practitioners, this legislation is unnecessary and would prohibit agencies from promulgating and implementing policies and procedures that suit the needs of the communities they serve. One of the things that these police chiefs are actually trying to protect are relationships with members of the community, and in many cases, vulnerable members of the community that have been very hard won over a long period of time, and that they clearly feel would be in jeopardy if we passed a bill like this. So, I realize we do have some former police officers who are on the Criminal Justice and Public Safety Committee, and I respect their opinions and I respect their expertise. But we also have people who are in law enforcement now who have contacted us on this issue and have weighed in decisively against it. Thank you.
Thank you. You're correct. They did weigh in decisively as it is written, and I would be interested in possibly changing that. But we can't pick and choose when we take their advice. They also said it was a horrible idea to legalize possession of 10 milligrams or more of a controlled substance, and we voted against that. So I think that we have to be pretty uniform in whose advice we take and for what. But again, I would want to change this and limit it strictly to, and this is happening. This isn't, they may say in their departments it's not happening, but we heard from the senator that this is happening in several departments where they have been ordered not to honor or notify ICE. And that if that's happening, that type of lawlessness can't be allowed in our state, because where you're only as strong as your weakest link. And if we have one town that is not honoring detainers from the federal government, and you can't have an ICE detainer for running a stop sign, that's not how that works. If they're ignoring ICE detainers by not even calling to say that we have this person, I feel like we're putting our entire citizenry at risk. By rolling the dice, assuming it's not an important thing and that they won't go on to hurt anyone after they've been released. Representative Mannion.
Thank you, Mr. Chair. I just want to go on record because I've been asked to let everyone know that I'm currently in law enforcement. I'm not a former law enforcement officer. I'm still currently employed as an officer, just so everyone's aware of that before I give any more testimony or anything. Thank you.
Okay. Representative Newman. Oh, you good? All right. Representative Newell, I'm sorry. That happens to Representative Murray too. I never see.
Too close, can't see me over here. I believe part of the testimony that we heard is that there are no sanctuary cities, and that's what the law enforcement officers were trying, like in the way that we define them. So we're defining sanctuary cities in different ways, right? We keep saying that there wouldn't be a detainer issued unless it were for a serious offense. For the serious offenses, it would seem that even in sanctuary cities, people are being held for crimes regardless of their immigration status or anything like that. So it comes back to the point, why are we doing this? Like, why are we putting this in place because it seems that it is not needed, it is unnecessary, and at the end of the day, what it seems like, or the impact of it, the effect of it would be further criminalizing and inhibiting participation from very vulnerable members of our community that we talk about. If we talk about public safety, those are part of the people that we're trying to protect, and yet we're putting them in a situation, unnecessarily, and with this kind of frame of mind of something that isn't actually happening, we're putting something in place that further inhibits people from fully participating in our society and in fully advocating for themselves as well. And the public safety part of that, of course, not only individually and not only in many different communities and part of our broader community, but also in the fact that if you actually want to be able to know and have people feel comfortable speaking up about something that is going wrong, about someone who is actually potentially dangerous or harmful, people need to feel comfortable in coming and speaking with law enforcement. So I feel like we're having this conversation about having this conversation about an issue that isn't even really an issue at this point, and the impact of us acting as if it is and putting further language in our statutes around something that isn't happening is worsening public safety rather than increasing or fixing it. Yeah. Okay.
Okay. So the proposal that I'm making, yeah, you may. I'm just going to respond to what she said. The proposal that I'm making with regard to only the ICE detainer portion of it would have no impact whatsoever on the relationships with the communities, on the protected people from not feeling safe. The only time that would even come up is if they were under arrest for a violation of a law. So I'm not sure how any of that stuff would apply to a situation where our law enforcement was mandated to cooperate on an ICE detainer. So I understand that as members of our community, first of all, it's not up to us to decide who or who is not in our community. That's up to the federal government. And if they're here, the federal government, let them be here. They're entitled to the same protection by law enforcement as everyone else. So once we find, however, through an arrest that they are wanted by immigration, I feel like we need to honor that as part of the cooperation between the state and federal government. But your point is taken. Representative Sitek.
I'd like to perhaps focus a little bit more on what you just said. After you blow all, there's a lot of foam here, but very little beer. I don't think any of this is necessary. I think the situation in New Hampshire is working fine. The only thing I want to prevent is if it exists, the aggressive prohibition that the local police department won't honor a ICE detainer. I have no other interest in the bill.
I agree wholeheartedly. That's basically what I would like to narrow it down to. As a matter of fact, I'm even willing to get rid of all the sanctuary words. I mean, that's really irrelevant to me. I just want to make sure that they're honoring the law. Further discussion. Representative Janvrin.
Thank you. I want to point out a few things here. And I better start with, I'm an elected law enforcement officer. If somebody is pulled over for breaking a motor vehicle law, which would be a violation level, and the police officer goes back to the cruiser, runs their history, and it shows that they have a warrant out of Connecticut, that police officer is immediately going to call Connecticut and say, are you going to come and get him for extradition? Well, they may not get an answer right away. So what does that police officer do? They let him go? No. They take him into custody. They honor that arrest warrant out of a foreign entity. And they take him to the jail for 48 hours. So if somebody has a warrant out of California, they're going to do the same thing. They have a warrant out of Florida, they're going to do the same thing. So there's absolutely no reason why, if they run that background check and they find that there's a detainer from the Immigration and Naturalization Service, that they shouldn't hold them as well. So we're talking about two different things, it boils down to, are we going to honor an extradition agreement? And I think we should be.
Well, indeed, you raise a good point. By refusing to cooperate with that, we're actually extending further protection to people who are wanted by the federal government than we are people who are wanted by our sister states. If there's a fugitive from justice warrant from another state, we hold the person. But if it's an immigration warrant from the federal government, we're going to ignore it. That doesn't make any sense to me. On any level, I just can't wrap my mind around how that would be good policy. I agree our law enforcement officers should not be enforcing federal law, but this isn't about enforcing federal law. This is about holding someone so that the feds can enforce the federal law, and they've asked us to do so. And it seems to me that people who are coming into the country in the last several years have been granted work authorizations and all kinds of things so that they probably are having proper documentation. So we should respect the same agency. In other words, you can't say, well, it's great that they're letting these folks in and giving them this opportunity to get jobs, but we're going to ignore them when they say they want them back for a reason. It doesn't make any sense. Representative Mannion.
Thank you, Mr. Chair. I heard some discussion about this not being needed because it's not happening and we have no sanctuary cities. Did we not hear testimony last week that there are some towns that prohibit their law enforcement from enforcing ICE detainers? Or did we not hear that? Okay, thank you.
So this is what I'm talking about, kind of the definitions of like, what is a sanctuary city? So I'm sorry, and I wish I did, to have, an example of this is what a sanctuary city is. Actually, my sheriff spoke, and I signed on to that letter, and my sheriff oversees my city, which is what we would call a sanctuary city. I mean, there are many different communities that have what they're doing is it's a resolution to say that we are not going to go out of our way. It comes back to the idea of the definitions where we're having a conversation about resolving an issue that literally does not exist. So yes, we can say there are cities that have passed resolutions that say that they are not going to encourage their law enforcement officers to go out of their way to chase down people. And, I'm sorry, I'm not putting it in the proper terminology, but our definition of whether or not, even in those cities, if there is an ICE detainer thing that is for something that is a serious crime, they will still be detained. It's not, they're not getting away with anything extra. That would be something that you would keep somebody from another state or something like that. We're talking about different things. We're talking in circles because we're trying to resolve an issue that doesn't exist in the first place.
Okay, so first of all, I disagree it doesn't exist. We heard testimony that there are towns that are prohibiting their officers from honoring ICE detainers. Second of all, I agree with you. I don't want to get into the definition of sanctuary policies because you're right. Some of them, it may be so innocuous as saying we're just a welcoming community versus some of them that say we're not going to enforce any federal law and we don't care if you're here with papers or not. So I don't want to get into that. As a matter of fact, I don't think it really belongs in here. I think what we should be doing is just focusing on, are there towns that are prohibiting their officers from enforcing or notifying ICE that they have someone? And if so, that's what we should address. And if it's not happening, then you're correct. The bill we don't need the bill. So we heard testimony, albeit second or third hand, that it is happening. So I think I'd like to find out more about that. I'd also like to find out from Representative Murphy the more details about the Merrimack case. So unless anyone has anything else to add, I think maybe we should just, we have until Wednesday. Yeah, go ahead.
I just was, for specific clarification, the difference between a warrant and a detainer, between those two terms, because ICE has detainers, and we've been talking about warrants from other states. So I just want to be really clear. And then I also wonder, regardless of the specific answer of that question, whether the amendment could vacate the entire contents of the bill and just say police departments shall not be told not to enforce federal law.
Bingo.
Period.
I like that. Yeah, we could. Yeah. Because at the end of the day, I think a lot of it is semantics, so that doesn't really go towards helping the law.
I'm sorry, I can't.
I
whatever
said,
sounds-
I said bingo. I think a lot of that is just fluff and semantics that don't necessarily contribute to enforcing the law. I'm not interested in defining what sanctuary is and what sanctuary isn't. I just want to know are our law enforcement officers being prohibited from cooperating with the immigration? And if they are, that's what we should address.
But shouldn't we make it, they could, not just immigration authorities, any area, like the DEA, the, I don't know, there's like 10 billion different areas of government. Any federal law enforcement agency, period.
I think that we already do, except for the law we specifically passed exempting certain firearms regulations. I don't think there's any other thing that we don't cooperate with. But I could put that in there. I wouldn't have a problem with that. Yes, Representative Harry Guthrie.
I agree with the issue around the different, or I heard the same things that you heard last week from folks that said that. However, I have not had a law enforcement person to say that. So I feel as though that we're listening to some of the rhetoric that comes with people as they discuss things. However, I personally would love to hear that from that police department or that chief of police in whatever town or city they claim is actually ignoring the laws or doesn't hold people for retainers.
I agree. I'm going to make
All
some
right.
inquiries to see if I can get some actual towns. Yes, Representative.
So then we
Newell.
won't have to say that this is a bill that doesn't have any merit.
So I just wanted to read from you. This is when I say that we are a sanctuary city welcoming committee, welcoming community. This is what I mean. And I'm just going to skip to the jump. This is the part where it says, now therefore be it resolved that the city of Keene will encourage that the following policies be adopted within the city of Keene. 1, to inquire into the immigration or citizenship status of an individual where the inquiry relates to a legitimate city purpose as required by the federal, state, or local law that is otherwise unrelated to the enforcement of civil immigration law. 2, to only assist U.S. Immigration and Customs Enforcement or Customs and Border Protection in actions intended to enforce federal immigration statutes when required to do so by a federal, state, or local law that has been deemed enforceable against the city or required of the city by a judicial court with competent jurisdiction over the city. I'm sorry, bad reading. Number 3, this is the last one, to only cooperate with ICE or CBP in a request to detain or report an individual when required to do so by a federal, state, or local law that has been deemed enforceable against the city or required by the city or judicial court which competent over the city. So the reason I want to say this is from 2017. So this is a little bit kind of prior to it becoming such a, kind of sensationalized issue, in my opinion. But at the end of the day, I think that's the reason why I feel like we're having such a difficult conversation here and why we're talking around circles is because what we are trying to implement in this law is not actually resolving a problem that exists. What it is doing is it is scaring people who are in vulnerable communities and creating, in my opinion, a much more precarious situation for the public safety of all of the members of our community, because we are being kind of ginned up to be concerned about 1 or 2 mass murders. And so I think this is unnecessary and harmful.
Well, I respect your opinion. Having said that, what you just read to me is exactly why we need this law. You just said to me that our community will not cooperate with ICE unless there's a state or federal law that says we have to do so. Therefore, I suggest that we may need a state law to make your community do that.
And I apologize for my bad reading because I'm not sure how you got
I'll
it.
read it. That's all right. Okay. Yeah, sure. Absolutely. Go ahead.
Well, wanted to point out a couple of things. One thing is New Hampshire is not required under federal law to support this in any way. No New Hampshire, matter of fact, no law enforcement agency in any state is required to support an ICE detainer. And I think Representative Selig made a great point when she noted that there's a difference between a warrant and a detainer. Federal immigration law is civil law. It is not criminal law. And I think one of the things where one of the reasons why I'm opposed to this is I continue to be cautious when it comes to the very slippery slope that we could be headed down when we start authorizing police officers to do things in the civil area, which is what this is. I think that there's a very real danger that whatever we do is going to wind up being challenged in the courts, and unfortunately, the particular process that we're following on this, I don't think is going to give us enough time to get anything in this area right. And I just think we need to be extremely cautious about any changes in this area, especially when we're telling people in communities that have put together elected boards and elected representatives that have made decisions based on the feedback they're getting from members in their own community to enact policies like this. This is one of those conquered things where we're going to be telling people, in another community that, oh no, once again, you don't know best, we know best, and we'll make the decision for you.
I'm pretty
I
sure
can't
every
go with
single
that.
one of our state laws does that. Criminal law applies across the state.
I represent Salem, not
Yeah.
Concord or the state. Basically, I represent Salem, and those are the people that tell me what laws they want to see enacted.
Yeah. I think that with regard to civil versus criminal, indeed, you are correct. Most of the ICE things are civil, but a civil detainer to pick somebody up doesn't mean that they're wanted for a civil offense. The prime example is the mass murderer who was working on a roof in Rye. It was an ICE detainer. Well, it was for murdering multiple people. So you can't just put a blanket, these are all civil, we need to leave them alone. Otherwise, that gentleman would still be working on roofs in the community of Rye today. So I think we do need to look at it, though, carefully. Representative Murphy.
Thank you. Just because I don't understand how this works, would it be possible, to your point that you just made, the difference between the detainer and the warrant, in that situation with that murderer, is there a way for a warrant to be issued based on you know what I
From
mean?
an
Like, it
extra,
wasn't
well, from an
clear,
out
but-
of state, there is. It's called a fugitive from justice warrant.
Okay.
But from another country, I'm
Yep.
not sure. I think that the detainer would be what they would use. But I'm going to make inquiries about that to
I was just
see if
thinking
there's
it's
a.
another way. I mean, if it's really like that murderer, if there was a warrant.
Well, yeah,
would
if
it-
there's a criminal detainer versus a civil detainer, I would say, okay, then let's look at the criminal. That's a
Yeah.
safety issue. So I want to see if there's a difference. Thank you, though,
thank
for
you.
that question. All right, with that, we're going to recess and we're going to pick this up again on Wednesday. I believe we have scheduled for executive session. Is that correct? Yes. Okay, so if there's new language to be brought, reach out to me. In the meantime, I'm going to pursue the avenues I discussed and possibly bring an amendment for us to discuss at executive session. With that, we are done for the day.